James Bay.
Speaker, I'm very proud to rise today to speak to Bill C-32, which would be legislation to update Canada's Copyright Act. I speak as someone who's actually tried to feed my family off copyright as an artist, as a writer, as a broadcaster, as a publisher. The New Democratic Party has been very clear about our desire to ensure that our copyright regime is updated. We place copyright reform at the center of what must be a much broader innovation agenda for Canada. That includes codifying protection for net neutrality, committing to national benchmarks for broadband access right across rural and northern Canada and into our urban areas, of course, enhancing our digital cultural programs to ensure that Canadians are able to fully participate as international citizens within a democratic, culturally vibrant public commons that is the internet. In terms of copyright reform, we've been very consistent. We've told this government, bring WIPO into the House and have it ratified. If we had done that, it would have taken some of the international pressure off Canada in terms of addressing international concerns. We've been telling this government that we support fundamentally the principle of remunerating creators for their content, and we oppose criminalizing consumers. Now, the Conservative government had 5 years to ratify WIPO and bring it before the House, and they stalled. And instead, in their first run at copyright, the previous bill was so poorly constructed that it pretty much died the day they brought it in. Because the first lesson you need to know about copyright is it has to be balanced. And to be balanced, you need broad-based consultations with every stakeholder. So the Bill C-61 was pretty much ditched as soon as it was brought in, and that sent the Conservatives back to the drawing board. So here we are 2 years later, 5 years into this government's term. I unfortunately don't think at this time the government has gotten the message. We will be more than willing to work with them on addressing problems, but we want to have a very clear understanding from this government that they're willing to work with the other parties as well to fix this bill. Now, many international observers are looking to Canada. They think this is a country that can actually get it right when it comes to copyright. Because, like every other nation in the world, we are in the midst of unprecedented technological change. And what we've seen over the last dozen years is a cultural copyright war that has been played out internationally. And some jurisdictions, quite frankly, have gotten the mix wrong. And I think if you look at the history of copyright and copyright, the push for copyright has always come from technological threat, and there's certainly those who are threatened, some older business models, who would use copyright to make sure that new, potentially difficult platforms for distribution are somehow stopped from going forward. And the fact is, I think what we've learned in Canada from watching other countries try and bring forward copyright is that no amount of legislation or legal action will force consumers to return to dead business models. And nowhere is this folly clearer than in the United States Digital Millennium Copyright Act, the DMCA. Now, the U.S. entertainment industry has used both the courts and legislation to try and criminalize consumers, and the result has been a scorched earth policy that was waged by the recording industry of America against its own consumer base. After 35,000 plus lawsuits against kids, single moms, and even dead people, the so-called digital genie hasn't gotten back in the bottle, and it's not going back in the bottle. And the one thing I'd say to this Conservative government, for all their dumbed-down approach to social policy, I think even they understand that suing kids is not going to be a constructive long-term solution, and that might be one of the only positive aspects we see from what we've witnessed south of the border. So, in terms of what a copyright approach should be, does this mean that digital technology has simply trumped the principle of copyright, and the endless downloading can simply erase the rights of creators? Certainly not. We need to look at the internet and digital innovation for what it is. This is an exciting new distribution platform, and new models are emerging. We have the opportunity in Canada to come forward with something that's forward-looking rather than backward-looking. I think we have to be careful. This is why I found it very unfortunate this summer when the Minister of Heritage denounced citizens who questioned the bill as digital extremists. If copyright reform is to succeed, we have to move beyond this self-defeating culture war. Because the choice really at the end of the day is whether we support regressive or progressive copyright. Now, regressive copyright is based on attempting to limit, control, or punish users of creative works. Regressive copyright is ultimately self-defeating because the public will find ways to access those works. Progressive copyright, on the other hand, is based on those two time-honored principles that copyright has always been based on: remuneration and access. The digital age has shown us clearly that consumers of artistic works want to be able to access those works how they want it, when they want it, and they will do so. And to them, the internet isn't a threat. It's an amazing vehicle to participate in an exciting cultural exchange. The question is how do we monetize it? Because the balanced approach represents the mainstream of Canadian copyright opinion, and I would refer you to the judgment in the case of Théberge versus the Galerie d'Art de Champlain Incorporated. The Supreme Court said in that case that the purpose of copyright was to strike a, quote, balance between promoting the public's interest in the encouragement and dissemination of works of the art and intellect and obtaining a just reward for the creator. So the role of copyright, this isn't simply enforcement of property rights, but it is a public construct. That's what copyright is, to ensure that there's access in the dissemination of works and a public interest in remunerating the creator. I don't think, unfortunately, that Bill C-32 manages to strike this balance, because it offers the public a series of rights in the same way that a roadside carny offers you good odds on the pea in the shell game. But unfortunately, if you try and access those rights under the digital locks provisions, you will find that none of those rights actually do exist. And that is fundamentally problematic, because all the rights that are guaranteed in this bill can simply be erased by a corporate piece of software to say that you can't access the works that you've legally purchased. Now, it's one thing to use the digital locks, and this is where the support for digital locks exists internationally, and I think we would agree that everyone in this house would agree. The digital locks exist to protect a piece of copyrighted material from being stolen, or as the Minister of Heritage said, from someone ripping it off and putting it on BitTorrent. But it's a whole other matter to use those digital locks to prevent access for educators or for consumers who actually bought a product that they would normally be able to time shift or format shift. And as for the remuneration of artists, this is the other fundamental principle in copyright. This bill consistently undermines the revenue streams that artists have relied on. And most noticeably, we can see it in this government's full-on political assault on the private copying levy. Because their attack on the levy is emblematic of them attempting to turn copyright into a political show battle in which they get to rant about taxes and go after taxes. But what they're really going after are some of the time-honored principles that Canadian copyright have been based on, which is the remuneration of artists. Now, before we get into the fundamental problems of this bill, let's put it in context. Technological change has always driven copyright reform, going right back to the very beginning. And music is a very good example. In 1906, John Philip Sousa denounced the threat of mechanical music, which was actually the roller piano. He felt if people started buying roller pianos, they wouldn't need live musicians anymore. Well, I don't know how many people ever bought a roller piano, but it wasn't quite the threat they made it out to be. Now, the American Publishers Association picked up this threat of technology when the record player appeared, because they said, well, if there's record players, then who's going to buy sheet music? And sheet music was actually one of the great copyright drivers for artists, because if people actually listen to records, they wouldn't have to play the piano in their parlor. And this was clearly a case of a new business model threatening an older existing model. Now, in 1923, those record companies that were the threats just a few years before now found themselves under threat because the radio appeared. And the record industry was saying, well, geez, if people can listen to radios and music on radios for free, why are they going to buy us our records? And by 1928, it appears that their fears may have been realized. Record sales had dropped off 80-some%. By 1931, they had dropped off over 90%. Now, I would argue that perhaps some of that had to do with the Depression, but the argument could have been made by the record company lobbyists at the time that the appearance of radio had had an effect. So, were the radio listeners criminalized? Did they put locks on your access to radio? No, they learned to monetize radio revenue. And the record industry never looked back until it came across the kid who had invented Napster. Now, Napster was enormously successful, not because the music was free, but because it offered a young generation almost unlimited access and the ability to choose what they wanted when they wanted. That was a phenomenal change in how music was accessed. And Steve Knopper, in his excellent book, Appetite for Self-Destruction, The Spectacular Collapse of the Recording Industry in the Digital Age, says the recording industry made a fundamental error, colossal error, when it decided to try and shut down the technology through lawsuits rather than monetizing.